If you passed away tonight, here's the reality. Your family would be locked out of every dollar sitting in your bank account. Not for a day, not for a week, for months. Your will wouldn't change that. Having it notarized wouldn't matter. Even a professionally drafted estate plan couldn't get them a single cent. But there's one simple form that changes everything. It's free, it takes minutes, and it sidesteps the entire problem. The reason nobody's told you about it? The people who profit from the current system have zero reason to bring it up. I'm Claire Weston. My job is representing taxpayers directly before the Internal Revenue Service. I negotiate on behalf of real people, sitting face-to-face with IRS agents and bank compliance teams. If content like this matters to you, go ahead and subscribe. Every single week, I'm breaking down the financial and legal realities that safeguard your money and your loved ones, and I do it in a way that actually makes sense. Here's the disaster I see over and over again, and it's completely avoidable. It's not some risky investment gone wrong. It's not even a tax filing error. It's families walking into a bank days after losing someone they love, only to be told they can't access money that belongs to them, all because one simple form was never completed. This form takes less than 10 minutes to fill out. There's no cost involved. You don't need a lawyer. And unless someone like me explains it, you'll never hear about it. Let's talk about the legal system still running the show when it comes to your money. Back in 1969, the National Conference of Commissioners on Uniform State Laws finalized something called the Uniform Probate Code. What they did was establish a principle most people are completely unaware of. Financial accounts at banks and credit unions are treated as contractual instruments, and they exist on an entirely different legal pathway than your will. Over the decades that followed, states across the country adopted this framework. Today, every state operates under some variation of it, and courts have backed it up repeatedly ever since. Here's what that actually means for you. The agreement you have with your bank, not your will, not any trust, not your estate plan, is what determines where your money goes after you die. When you fill out a beneficiary designation form at the bank, that document overrides your will. It doesn't matter if your will was witnessed, notarized, and written by the best attorney in town. The bank contract wins, every single time, no exceptions. Your will controls things like your furniture, your vehicle, jewelry, and everything else inside your home. But your cash? That's controlled by the bank contract. When you die and there's no beneficiary listed on your bank account, the money doesn't go to your heirs. It goes to your estate. The moment that happens, probate kicks in automatically. Probate is a court-supervised process where your will gets validated and your assets get distributed under the watch of a judge. In most states, probate gets triggered when your account exceeds somewhere between $50,000 and $100,000. For most retirees, that threshold gets crossed easily. Once probate starts, your family waits. The court operates on its own timeline, not yours, and definitely not theirs. Here's the part people don't grasp about probate. It's not some quick administrative formality. Most states have a legally required creditor notification period built right into the process. That's typically 3 to 6 months. During that time, anyone who might have a claim against the estate, whether it's a medical provider, a credit card company, or any unknown creditor, gets the opportunity to come forward before anything gets distributed. Your family is stuck waiting until that entire window closes, no matter how clean your financial situation was. And while they're waiting, life keeps happening. Bills don't pause. Funeral costs don't wait. Grief doesn't come with a financial freeze button. That brings me to Dorothy's situation. She did everything the right way. It still didn't matter. Dorothy was a 71-year-old retired school teacher living in Illinois. She had just sold the family home and walked into her local bank with $350,000 from the sale. She opened a standard savings account, then hired an estate attorney for $800. She got a full will drafted, properly witnessed and notarized, with clear instructions naming her 2 adult children, Michael and Sarah, as equal beneficiaries. She placed the will in a lockbox under her bed and called Michael to let him know everything was taken care of. But it wasn't. Dorothy had a stroke. She didn't survive. Michael and Sarah flew in. The funeral cost came to $11,500. Michael took the death certificate and the notarized will straight to the bank. The branch manager pulled up the account, looked at the will, and pushed the paperwork back across the counter. Dorothy had never completed a payable-on-death beneficiary form. The account listed only her name. Since the balance was well above the state's small estate limit, the bank had no legal power to release anything. A will is essentially a set of instructions written to a probate judge. It carries zero authority at the bank counter. The bank's legal duty is to the contract they have on file. That contract didn't name anyone. The account was locked. Michael and Sarah left the bank empty-handed. They covered the $11,500 funeral bill themselves, putting it on personal credit cards that charged interest rates above 20%, which was typical for consumer cards at the time. Meanwhile, $350,000 of their mother's money sat just feet away, completely out of reach. Then probate started. Just to open the estate in court, the filing fee was $389. Illinois law required them to publish a notice to unknown creditors in a local newspaper for 3 consecutive weeks. That cost another $250. The executor bond premium added $1,000, and those were just the upfront costs. The probate attorney charged a percentage of the total estate, which is standard in many states. For an estate this size, that fee exceeded $10,500. The mandatory creditor waiting period kept the case open for months. From the day Dorothy died to the day her children finally received access to the money, 14 months passed. They lost over $12,000 in documented costs, and the interest on the credit card they used for the funeral kept piling up the entire time. Dorothy didn't do anything wrong. She had the will. She had the notary. She hired the attorney. None of it had any effect on the bank contract. This wasn't a mistake on her part. It wasn't unusual. It was the entirely predictable outcome of a system functioning exactly as it was built to function. And there are 3 specific points where families fall into this trap. Before I explain those 3 failure points, I want you to do something. Pull up your online banking right now, or grab your most recent bank statement. Look for anything labeled beneficiary. If you can't find it, or if it's blank, you already have your answer. Write down what you see, because what's on that form, or what's missing, determines which of these traps applies to you. 3 ways people accidentally lock up their own money. The first failure point is having no beneficiary designation on file whatsoever. This is what I run into most often. You opened the account years ago, maybe decades ago. Nobody at the bank brought up beneficiary designations. You signed the paperwork and walked out. You figured your will would cover it. It won't. Under the contractual system, now written into state law across the entire country, a will has no control over a bank account. The account automatically defaults to the estate. Probate starts immediately. For a retiree with limited income, this can be devastating. A 6-month probate process on a $60,000 account can eat up a serious chunk of that balance in legal fees, filing costs, and publication expenses before the family sees a dime. For middle-class retirees, the assumption is usually that the estate attorney already took care of it. Most estate attorneys write wills. They don't file bank beneficiary forms. Those are 2 completely separate documents handled by 2 completely separate institutions. Almost no one explains that distinction when you're writing the check for your estate plan. The second failure point is having an outdated beneficiary on file. This one is actually more dangerous than having no beneficiary at all because it creates a false sense of security. You named someone 20 years ago. Maybe it was an ex-spouse. Maybe it was a parent who's no longer alive. Maybe it's a sibling you haven't spoken to in years. That name is still sitting on the form. That's exactly who the bank will send the money to. Your will might say something completely different. It doesn't change anything. The Uniform Probate Code, and every state that's adopted it, is crystal clear. The designation on file at the bank is what counts. Period. Courts have consistently ruled against surviving spouses, adult children, and estate executors who assumed a current will would override an old bank form. It won't. The bank looks at what's on file with them, not what's sitting in your lockbox. The third failure point is the joint ownership assumption. A lot of married couples think that just because they're married, everything automatically transfers to the surviving spouse. In many states, that's flat out wrong. Joint tenancy with right of survivorship is a specific legal setup that has to be explicitly created and documented at the bank. Being married doesn't automatically establish it. What matters is the account structure, how the title is listed on the account, and how your state treats marital property. The marriage certificate alone doesn't determine anything. And there's a hidden trap inside the most common fix people try. A lot of seniors add an adult child directly onto their account as a joint owner, thinking it gives the child easy access to handle bills if something happens. The intent makes sense. The legal consequences are serious. The second you add someone else to your account as a joint owner, the law in most states treats that money as partly theirs right now while you're still alive. If your child gets into a car accident and gets sued, the person suing can go after your bank account. If your child gets divorced, their spouse can claim a portion of your savings in the divorce settlement. If your child owes back taxes, the IRS can levy your account to collect. Joint ownership immediately transfers all of your exposure to every legal and financial liability your child carries. Completely. The POD designation avoids every bit of that. It gives your beneficiary exactly 0 ownership rights while you're alive. Your money remains entirely yours, fully protected from their creditors until the moment you die. Then the transfer happens cleanly, based on the contract, with no court involved. All 3 of these failures have the same solution. One form. Free. Available at your bank right now. So here's what I want you to do. The exemptions, the tax breaks, the refunds most seniors already qualify for but never actually claim, I've compiled them all in one resource. It's organized state by state, form by form, so you're not spending hours trying to navigate government websites. Everything is laid out clearly and simply, so any senior can quickly identify exactly what applies to them. No matter where you live, there's money you're entitled to that you're leaving behind. It's called the Senior Exemption Playbook. You'll find it in the first pinned comment directly below this video. Just click it once and you'll have everything you need. Stay with me, because the next section covers the one form that eliminates all of this, and it's the entire reason I made this video. The form that makes probate irrelevant. The form is called a Payable-on-Death designation, or POD. The legal concept goes back to a New York court case from 1904 called Matter of Totten. That case established that money could transfer directly to another person when you die without needing a formal trust or any court process. That principle was later written into the Uniform Probate Code, specifically Section 6-101, and has since been adopted in some form across all 50 states. It's not a will. It's not a trust. It's a contractual instruction you give to your bank, and it operates on the exact same contractual pathway that locked up Dorothy's account. Because it works on that same track, it completely bypasses probate. The bank doesn't check with the probate court. It checks the designation on file. When you have a valid POD recorded, your beneficiary just brings a certified death certificate to the bank. The designation gets verified. The transfer gets processed. No judge, no attorney, no filing fees, no mandatory waiting period. How long it takes depends on the institution. Smaller banks might process it the same day or the next business day. Larger institutions usually take 3 to 5 business days. What it doesn't take is 14 months. Filing a POD designation costs absolutely nothing. Every FDIC-insured bank in the country is legally required to offer it. Every federally insured credit union offers the equivalent. There's no fee to file it. There's no annual maintenance fee. It's free because it generates 0 revenue for the bank. It exists purely to serve you and whoever you name on it. What the POD form doesn't cover, and what to file instead. This is where most people stop. And this is where most people leave dangerous gaps. The POD designation covers your individual bank accounts, checking, savings, money market. It doesn't automatically extend to every financial product you hold, even if they're all at the same bank. Certificates of deposit need a separate designation. A CD sitting at the same branch where you filed your POD for your checking account isn't covered by that form. Each account is its own contract. Each contract needs its own beneficiary designation. If you're holding 3 CDs at the same bank, each one requires its own POD filed individually. Brokerage accounts use a completely different form. It's called a Transfer-on-Death designation, or TOD. It works on the same legal principle as a POD, meaning it's a direct contractual transfer that avoids probate, but you file it with your brokerage firm, not your bank. If you hold stocks, bonds, or mutual funds in a brokerage account and there's no TOD on file, those assets go through probate, just like an undesignated bank account would. Retirement accounts like IRAs, 401ks, and 403bs already operate on a transfer-on-death framework by design under federal law. But most people filled out their beneficiary form when they first opened the account, and that might have been decades ago. They've never gone back to update it. An outdated name on a retirement account creates the same problem as having no name at all. Sometimes it's even worse. Under federal law, the named beneficiary on a retirement account overrides any conflicting will or divorce decree. If your ex-spouse is still listed on an IRA you opened back in 1995, they could legally collect the entire balance. It doesn't matter what your will says. It doesn't matter what your divorce agreement says. It doesn't matter how many years have gone by. Review those designations today. There's one more asset worth mentioning, the safe deposit box. A lot of seniors keep their will, property deeds, and valuables inside one, and they give the spare key to a family member. That key gives them nothing after you die. Federal regulations require banks to seal safe deposit boxes as soon as they're notified of a customer's death. Your family will be denied entry, even with the key in their hand. Even worse, if the physical copy of your will is inside that box, they're stuck in a catch-22. They need the will to start the probate case, but they need a probate order to open the box. The fix is simple and free. Add your child as a joint renter on the safe deposit box contract at the branch. Both of you sign together, and they keep access no matter what happens to you. What to do before you close this video? Step 1. Go to your bank this week, either in person or through your online portal, and request the Payable-on-Death beneficiary designation form. Every FDIC-insured bank is required to provide it. If the teller doesn't know what you're talking about, ask for the branch manager. Step 2. Name a primary beneficiary using their full legal name, date of birth, and social security number. Don't use nicknames or vague terms like "my children." The social security number is how the bank confirms identity when the transfer happens. Without it, the payout can get delayed. Step 3. Name a contingent beneficiary as a backup. If your primary beneficiary dies before you and there's no contingent listed, the account defaults back to the estate and probate opens all over again. Step 4. Submit the form in person and ask for written confirmation that the designation has been recorded. Keep that confirmation with your other important documents. Step 5. Check every account separately. Your checking, your savings, and each individual CD all need their own designation. One form doesn't cover everything. Step 6. Contact your brokerage and file a transfer-on-death designation for any non-retirement investment accounts. Step 7. Review the beneficiary designations on your retirement accounts and update any outdated names immediately through your plan administrator. Step 8. Revisit all of your designations every 3 years or after any major life event. A death, a marriage, a divorce, a new grandchild. Tonight, your family still can't access a single dollar in your account. That's the truth right now, unless you file this form. The probate system isn't broken. It's doing exactly what it was designed to do under the framework adopted from the Uniform Probate Code. The POD designation is the one tool that operates on the same contractual track and beats it. Go to your bank this week. Ask for the POD form. It doesn't cost anything. It takes 10 minutes. And if you found this helpful, subscribe.